All rise.
The Kosovo Specialist Chamber.
Be seated. Good morning, everyone. Madam Court Officer, would you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-07, the Special Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Thank you. I see Mr. Helling is back with us today, and there's no other change in the prosecution's team. Mr. Rees?
Same representation as yesterday, save that I'm additionally assisted by Mr. Vladimir Dashi this morning.
Mr. Cadman?
No changes this
Thank you. I do note that Mr. Haradinaj and Mr. Gucati are both present in the courtroom. The panel has an oral order to render on the admission of the exhibits tendered through witness 4841, Ms. Pumper. Written reasons will follow next week. The panel heard the testimony of witness 4841 between 18 and 26 October 2021. During this time, a decision on admission was deferred in relation to a number of proposed exhibits. On 28 October 2021, the panel heard oral submissions from the parties regarding the admissibility of these exhibits. Having reviewed the exhibits and having carefully considered the parties' submissions, the panel decides as follows. The general admissibility objection of the defense is rejected. The panel admits into evidence all exhibits under categories 1, 2, 3, 5, and 6. The panel considers that the items under category 7 are not judicially noticeable, but admits them into evidence as individual exhibits. The panel also admits into evidence as individual exhibits all items under category 8 except the item with ERN number 07891-078982. The panel does not admit the item under category 9. Regarding the item marked as P104 under category 4, also referred to as batch 2, the panel makes the following ruling. In light of the complete redaction of the 6 pages containing relevant information, the panel is not in a position to make findings in respect of the authenticity, reliability, and probative value of the material concerned. The panel therefore varies in part the decision of the pretrial judge rendered on 23 February 2021, and that is F141, regarding the undisclosed part of batch 2. The panel invites the SPO to produce an unredacted or lesser redacted version of P104, redacting only what is absolutely necessary in the circumstances, and to resubmit that material for admission. The panel notes that if the SPO seeks admission once again of this item, the documents should be capable in all material respects of a determination of its authenticity, relevance, and probative value. If the SPO chooses to do so, it is ordered to disclose an unredacted or lesser redacted version today, 5 November 2021. If that happens, the defense is ordered to indicate by 8 November 2021 in oral submissions during the hearing whether it wishes to further cross-examine witness 04841 in view of the SBO disclosure. Detailed instructions to the registry regarding the specific items will be included in the written decision to be filed next week. The same decision will also address the classification of these items and also the deferred classification of some of the already admitted exhibits. This concludes the oral order. Now, we move on to discuss the next steps in the current proceedings. For the benefit of the public, I note that we are nearing the end of the SBO case. We have one witness left who will start testimony today and finish either today or on Monday. Then we may have some further cross-examination on Monday and maybe Tuesday, depending on the disclosure by the prosecution today regarding P104 and the two pending Rule 102.3 matters. We also have one additional matter pending under Rule 102.3, which may also lead to request for further examination in the week of 15th of November. At this point, I would like to hear from the prosecution if witnesses 4841 and 4842 can be made available on Monday and maybe in the week of the 15th of November for any further cross-examination if requested by the defense for the narrow purposes just outlined. Mr. Prosecutor.
Yes, Your Honor, I will make inquiries about it, and if it's okay, we'll let you know after the next break.
Thank you. In any event, strictly speaking, the presentation of the SBO's case will be finished early next week, which is in line with the 9 November target date that we had set. The panel is grateful to the parties for keeping the efficient pace of these proceedings. We know it hasn't always been easy, but we have made good progress so far. Now, according to Rule 130, immediately after the closing of the SBO case, the defense must notify the panel whether they intend to file a motion to dismiss any or all of the charges. We know that some further cross-examinations are still pending, but the panel would welcome an indication from the defense on Monday during the hearing whether it expects to file such a motion. The panel would also welcome an indication during the hearing on Monday whether it plans to call a defense case as to both accused. We know that according to Rule 119, no such notification is required before the resolution of any motion to dismiss charges, but the panel invites the defense to share whatever information they can, so a realistic timeline can be set out next week, and so as to ensure that proceedings are conducted most efficiently and for the benefit of all, not the least the accused. In particular, it would be very helpful to get a proposed estimate from the defense on when can they file their witness and exhibit lists, and when will they be ready for the defense preparation conference. The panel would also like to know if any material changes are expected to the proposed witness lists, in particular whether the defense teams intend not to call some of the witnesses currently on their lists and whether they still intend to call their clients. Of course, this is all dependent on whether a motion to dismiss charges is filed, and we are aware of that. Now, Mr. Rees, Mr. Cadman, this is just a heads up for the next steps, but you are welcome to comment at this time if you want. Any information is highly appreciated. We'll begin with Mr. Rees.
We do anticipate a motion to dismiss. We also anticipate that in the event that there is a case to answer on some or all of the charges, that there will be a defence case called. We'll reflect on Your Honour's comments and be in a better position to assist next week.
Okay.
And we will be as candid as we feel appropriate in the circumstances, because I certainly agree that it's in everyone's interest, not least the accused, for a clear timetable to be set out. Can I just address briefly the issue of potential recall of witnesses 04841 and 04842? We're conscious that the order that had previously been given by the trial panel gave us until the end of Monday to give an indication as to whether we seek recall. There is an outstanding order for disclosure to be made, as I understand it, by the end of today by the prosecution, with a further outstanding disclosure matter yet to be resolved, and will not be resolved until, on the timetable currently set out, as we understand it, after November the 12th. We would urge that the decision on recall await the finalisation of all outstanding disclosure requests, because it would not seem to us to be useful use of court time for any further recall of those two witnesses to take place in bit part. If there is to be recall, we would ask for that to take place once all disclosure matters are resolved, that the defence are provided with all such disclosure as they will receive, and then any further recall, cross-examination can take place in a complete form, and then those witnesses can be released, as it were.
We'll take that under advisement. We'll make a ruling later today on your request. Mr. Cadman?
Your Honour, certainly on the disclosure point, I take Mr. Rees's point and support it, so we'll await your ruling by the end of today on that point. As far as an application to dismiss is concerned, our position based on the prosecution case presented thus far, we do anticipate making such an application. Obviously, we will come to a final decision once the prosecution case is completed. And in terms of what evidence we intend to call, as Mr. Rees has said, we will be as pragmatic as we can, ensuring that we are only calling those witnesses that are necessary to the charges that may or may not need to be dealt with. The only matter that I do need to address Your Honours on concerns the additional expert who made contact late last night, who's currently in Queensland, Australia, so there's quite a time difference in being able to communicate. He has indicated that he has completed the main part of his report. We have not seen a draft, but he has completed. But what he needs to consult the publicly available transcripts of Ms. Pumper's evidence in order for him to finalise that. He has asked whether he could have until Monday to finalise his report. I have impressed upon him the need to expedite matters as quickly as possible. Obviously, some delay was as a result of no inter-parties communications with the SBO. I take their point on that, and I'm not criticising that. I'm just stating that as a fact. The other issue is the delay in getting publicly available transcripts, which so far we only have, I believe, two of those for Ms. Pumper's evidence. I'll certainly take that up with the registry today so that we can get the transcripts to him today so that he can consider that over the weekend and finalise his report for Monday. And if Your Honours grants us leave to an extension until Monday to serve that report, we would be most grateful.
We'll take that up together also and rule on that later today as well.
Thank you, Your Honour. Just briefly, because the disclosure deadline set for today was mentioned by Council, I do want to inform the Court that we are, of course, aware of that deadline. We are currently considering our options in relation thereto, and should we be filing any leave to appeal, we would intend to do so today. And if we do file a leave to appeal, we would also seek suspensive effect of the order. And as I said, I will know more about this matter a little bit later, in view of the fact the decision was rendered very recently. But I did just want to put that as an information, because that may have an impact on future proceedings. Thank you.
Thank you, Mr. Patch. One other question is whether the accused wished to make a statement at the closing of the SPO case. As the panel has said before, we will give the opportunity to the accused to make unsworn statements at specific times during the proceedings. Monday could be such an occasion, if they prefer to do so at the beginning of their case. Any comment that you have on that, Mr. Reese? Not required, but we're just asking for a heads up.
We're grateful. I anticipate that Mr. Gucati will wish to make an unsworn statement, and the end of the prosecution case would seem to be an appropriate point for us.
Thank you. Mr. Cadman, how about?
I will certainly confirm that by the end of today, but the position is likely to be the same.
Okay, thank you. I also invite the parties on Monday to bring forward any other matter they wish to solve before we go to the next stage of the proceedings. For the next topic, we will go into private session because it involves a protected person.
Your Honors, we're in public session.
Thank you, Madam Court Officer. For the benefit of the public, during the private session, the panel heard arguments regarding the application for an in-court protective measures of witness 4876. The panel recalls that it denied previous similar requests by the SPO and the Witness Protection and Support Unit because it found no objective, concrete indications that the public disclosure of the witnesses' names meant that there was a real likelihood that they or others may be in danger. The current request is no different from the previous ones. The alleged risks, while theoretically possible, have not been shown to be more than hypothetical in this case. The panel also recalls its finding on the decision on protective measures, that is F303, that SPO staff members fall into the category of witnesses who are members of the police or associated investigative authorities, and that it is in the nature of things that their duties may involve giving evidence in open court. The request is therefore rejected. Mr. Reese and Mr. Cadman, what is your cross-examination estimate for witness 4876? Mr. Reese?
Up to an hour.
Thank you. Mr. Cadman?
Your Honour, a lot will depend upon what the witness says, but I will certainly try to, I will assess what Mr. Reese deals with, whether there's any need to put anything further, but I certainly don't expect to be very long.
Thank you. We will, in order to notify the next witness of the decision that we just made, we will take a 15-minute break. You can stay where you are if you wish and relax, and we will leave the room, and we will come back after a 15-minute period. So we are adjourned briefly for that purpose.
Do you mind if we leave the room?
No, I don't mind if you leave the room, just so you're nearby.
Thank you.
Yeah.
All rise. All rise.
Be seated. Before we bring the witness in to testify, we remind the parties that the scope of the testimony in chief of 4867, as set out in F408, is that he can testify about his recollection of the events addressed in P92, P103, P105 MFI, and in the official note 102-754 and 102-755. In addition, in its recent decision on the Rule 102.3 matters, that is F413, paragraph 81, the panel also permitted the Gucati defense to question the witness on some of the entrapment allegations. Please keep in mind these perimeters when questioning the witness. We will now call the witness in, Madam Usher. Good morning, Mr. Moberg. The court usher will provide you with the text of a solemn declaration which you are asked to take pursuant to Rule 141, paragraph 2 of the rules. When you are ready, please proceed.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge.
Thank you, Mr. Moberg. You can be seated.
Thank you.
Mr. Moberg, today we will start your testimony. As you may know, the prosecution will be asking you questions first, and once they are finished, the defense has the right to cross-examine you. Members of the panel might also have some questions for you. The prosecution estimate for your examination is 2 hours. The defense's estimate is approximately 1 hour. Those are not promises. Those are just estimates that we hope to stick to. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. The panel understands that you might be asked by the SPO to attest to some corrections made during your statements. If and when that happens, you are reminded to confirm on the record that the written statement, as corrected by the list of corrections, accurately reflects your declaration, if it does. Please also speak into the microphone and wait 5 seconds before answering a question and speak at a slow pace so that the interpreters can stay up with your statement. While you're giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony. If any person asks you questions outside the court about your testimony, please let us know. Mr. Prosecutor, you may begin.
Thank you, Your Honor. Good morning, Mr. Witness.
Good morning.
We know each other, but I'll ask you some questions to establish your identity and background for the court. What is your name?
My name is Daniel Moberg. In my passport, there will be more names. As Swedes, you often have several first names, so that would be as well Lars, Johan, Daniel Moberg. However, Daniel is the one that's being used.
Where are you currently employed?
I'm employed with the Specialist Prosecutor's Office.
What is your current position with the SPO?
My current position is Operational Security Officer.
And did you occupy that same position in 2020?
Yes, I did.
Do you recall attending the KLA War Veterans Association premises in Pristina on the 8th of September 2020?
Yes, I do.
Could you tell the court what you went there to do that day?
I went there with a court order to seize documents that had been delivered to the KLA War Veterans Office.
And when you went there, did you do anything with that court order that you mentioned?
Yes, a copy of that court order was provided to the secretary of the KLA War Veterans Association as a representative of that organization.
And you mentioned that you also went there to seize certain documents. During your time on the 8th of September, did you seize any documents?
Yes, I did.
And do you happen to remember what you did with the documents you seized that day?
After seizing the documents, they were taken back to our offices in Pristina, where colleagues were scanning them to send them back to the office digitally. Sorry.
No, please go on if you have any relevant information on this issue.
Afterwards, they were also locked away in a safe, and then the originals were then taken back to The Hague about potentially 10 days later.
And how do you know about where they were stored and how they were transported?
I stored them in the safe of our premises, and I also handed them over to the prosecutor, transporting them back to The Hague.
When you stored them in the safe, were the documents stored in the same manner you received them? Were they in anything, contained in anything?
They were placed in 2 evidence bags.
And do you know who placed them in the evidence bags?
I believe I did that myself.
Did those evidence bags contain only the items you seized from the KLA War Veterans Association that day, or were there any other items?
I believe there would also be the handover document, which was signed by the secretary and myself at the time of the seizure.
Were these bags sealed when you put them in the safe for storage?
I cannot say for sure they were sealed at the time of being placed in the storage, but I know they were at least sealed at the time of being taken back to The Hague.
And do you remember who would have sealed them?
Most likely that would have been done by myself.
I'd now like to show the witness a document, and that is P92 MFI, ERN 083988 to 083991 RED. Mr. Witness, can you see a document on your screen?
Yes.
And do you recognize this document?
Yes.
Could you tell us in general what this document is about?
The document details the events taking place at the time of the seizure and how the documents were seized.
And to be clear, the seizure, is that the one you were referring to just before I showed you this document, the one on the 8th of September?
That is correct.
if the court officer could kindly turn to page 083990 of the same document, please. Mr. Witness, do you recognize your signature on this page?
Yes, I do.
And Madam Court Officer, if we could go back to the first page. Thank you. Mr. Witness, we see on this first page at the top an SPO logo and the words official note underneath that. And beneath those, we have a table with information described as date, author, and subject. And then below the table, we have some text about a subject. Could you tell us whether this is a standard format for such notes within the SPO, to your knowledge?
To my knowledge, this is the standard format.
And when we look at the text of this note on the first page, as well as the subsequent pages, we see reference to events which took place in paragraph 1 and following that on the 8th of September 2020. If we can then turn to the last to page 083990, at paragraph 14, we see reference to an event on 17 September 2020. And at paragraph 15, to an event on 21st October 2020. Do you follow thus far, Mr. Witness?
Yes.
Now, Court Officer, we could please go back to the first page, 083988. And Mr. Witness, in the table by the word date, we see 21st October 2020. Could you explain what this date refers to, bearing in mind the 3 other dates also mentioned in this note?
I believe that date would be the time of putting this in the text into this format, and also providing the DVD that was mentioned as an attachment, which was a short film clip taken with my work cell phone at the time of the seizure from the CCTV of the premises at KLA. And I believe that's when the document was handed in to, can't remember who I handed this into.
And you're talking about handing it into, just in general, for what purposes would you be handing this document over to someone?
To be submitted into Xylab.
And very briefly, could you tell us what Xylab is?
A collection of all relevant material collected by the SPO.
Mr. Witness, do you recall earlier this week being provided with an opportunity to provide any corrections or clarifications to this official note?
Yes, I do.
And Madam Court Officer, if side by side with the note on our screen, you could kindly call up item 103915 to 103915. And this does not have an MFI. Mr. Witness, do you recognize the document on the left of your screen?
Yes, I do.
And if you look at the text below the ERN 083988, we see 2 bullet points. Could you confirm that these are the clarifications or corrections you had in relation to the note on the right side of your screen, the one dated 21st of October?
Correct.
And considering the clarifications on the left of your screen, is the information you provided in the document dated 21 October accurate and truthful to the best of your knowledge and belief?
Yes.
Does the information in the document dated 21st October, including these clarifications on the left side of your screen, accurately reflect what you would say if you were examined about the events recorded therein?
Yes.
Your Honor, at this stage, I'd like to seek admission of the document, the one which is P92 MFI, along with its Albanian translation. And in addition to that, the note on the left side of our screen, which is item 103915 to 103915, since that contains relevant clarifications. And in terms of classification of the note dated 21st October, prior to this note being made publicly available, we would only seek to make reductions to the name of the second operational security officer referred to therein, not to the witness in view of this morning's ruling, and also to the name of the independent observer.
Any objection by the defense?
No, Your Honour.
Mr. Cadman?
No, Your Honour.
P92 MFI will be admitted as P92 plus the Albanian translation. The document 103915, 103915, being a correction of official note, needs to have a P number assigned to it.
Your Honor, that will be P138.
P138 is admitted in evidence. The classification will be public, except as noted, the two names on the note will be, may be redacted prior to making it public. Go ahead.
Your Honor, just to be clear, would it be okay for the prosecution to provide that reduction, or is that something the registry will do itself? We're happy to provide it.
Prosecution can provide the redaction and then offer it for approval.
Thank you, Your Honor. Mr. Witness, during this 8th of September seizure that we referred to earlier today, did you tell anyone present at the KLA War Veterans Association premises that they could keep the documents you were there to seize for up to 30 days?
No, I did not. No such discussion took place.
Did you say that they could keep those documents for any period of time?
No.
And to your knowledge, did you say anything which could be understood to imply that this retention could happen?
No.
Do you recall whether the other SPO staff member who was present spoke during the seizure at all?
The second SPO staff member did not speak at all during the entire meeting.
And to your knowledge, did you collect all the documents made available to you by the KLA War Veterans Association representatives that day?
I collected all the documents that were provided to us.
And Mr. Witness, other than this seizure on the 8th of September, did you attend the KLA War Veterans Association for seizures after that date?
Yes. Twice.
Do you happen to remember the dates of those two seizures?
I cannot remember the dates from the top of my head.
I don't think it's controversial if I propose those dates. I don't know if counsel has any opposition to me stating those dates. So Mr. Witness will refer to the second seizure as having taken place on the 17th of September and the third one on the 22nd of September. Now, referring to both these seizures, the second and third ones you attended, did you yourself speak to any KLA War Veterans Association representatives or members?
As I don't speak Albanian, it might only have been courtesy greetings, etc. But I also spoke to Mr. Haradinaj, as he speaks Swedish, and he knew that I was Swedish. Those conversations were basically on general life situation, greetings, etc.
So in your greetings and your conversation with Mr. Haradinaj, did you say anything on the lines of an ability for the KLA War Veterans Association to be able to keep the documents the SPO was there to seize for any period of time?
No.
And to your knowledge, did anyone else present that day on behalf of the SPO make any such statement, if you know?
Not to my knowledge.
I'd like to focus next on the seizure of 17th of September, which is the second time you attended the premises for a seizure. Could you tell us what your role was during this particular seizure?
Partially my role was to guide the investigator that was with me to do the seizure of where this office would be found, as I had been there before and I know where it was. I was also there to support in terms of security, and I also carried the bag for seizuring documents.
And could you tell us what you remember about the events that day from the moment you and your colleague entered the KLA War Veterans Association premises? And just a reminder, we're here talking about the 17th September, so the second time you went there.
Mm-hmm. I have some difficulties differentiating between these two events of what took place at what of those two, the second two events.
In that case, Mr. Witness, let's start by addressing both events together. So I'm now going to ask you, at first at least, a little more generally about both the second seizure of the 17th September and the one on 22nd September.
Hold on, Mr. Rees.
Your Honor, I will wait to hear the question, but it does seem to me to be a difficult concept for the witness to address both dates together.
Well, we'll give him a chance to ask the question. Go ahead.
Mr. Witness, as I was saying, you mentioned that you are finding it a bit difficult to distinguish, so I'm going to ask you, and you can answer with reference to both, or if you're able to specify which, feel free to do so. Do you happen to remember whether on the 17th or on the 22nd any documents were served on the KLA War Veterans Association representatives?
Documents served from SPO.
Correct.
I believe documents were served both times, but as I was not engaged myself in the talks, I cannot really differentiate.
And are you able to recall whether any documents were actually seized on one or both of those occasions, the 17th and the 22nd?
On both occasions, documents were seized. At one of the occasions, we were taken up from the office of Mr. Gucati, up one floor, I believe, to a larger conference room where the documents were laid out on several tables. And that took place at one of the events.
Do you recall how the documents were transported outside of the KLA War Veterans Association premises on one or both occasions?
I know that on one of the occasions, I believe it was the first of the two, the documents were handed over. The documents were transported by myself, and they were handed over to my line manager somewhere in Pristina for a quick review.
Could you give us the title of your line manager's?
Microphone, please.
Apologies. Without mentioning a specific name, could you give us the title of your line manager, his position?
Yes, this was the head of Operational and Witness Security Unit.
And to be clear, is it you yourself who took these documents you seized from the KLA War Veterans Association to your line manager that day?
Yes.
And when you took those documents to your line manager, were they in a loose format or were they contained in any envelope or other item?
They were in evidence bags, not sealed.
Do you have any memory what happened as to what happened after you gave these documents to your line manager? Did he give them back to you? Did he do something with them, or if you don't know?
I believe at this time they were scanned and sent back to the office, and also compared to the previous seizure.
You said that documents were scanned and sent back to the office. Just so we're sure, I'm sure that I'm understanding, the scanning of documents, the documents scanned were those that were seized at the KLA Robertsons Association on that occasion?
Correct. The documents seized were scanned and encryptedly sent back to the office in The Hague.
And you also mentioned a comparing of documents, I believe. Could you tell us, you said compared to the previous seizure, could you clarify what that means?
Yes, I believe staff members of the SPO were comparing the documents seized to the documents seized previously, and this took place in the office in Pristina. I did not take part in this, so I don't know the details.
Jonas, I just need 1 minute to confer with my colleagues.
Go ahead.
Thank you, Mr. Witness. The prosecution has no further questions for you at the moment.
Sorry, I didn't have my mic on. Cross-examination, Mr. Rees.
John, just give me a moment. Mr. Moberg, you are an operational security officer, is that right?
Correct.
The live transcript picked up that you said you were a witness security officer. Was that a transcription?
I believe so. My title is Operational Security Officer.
Yeah. So you're not involved in investigations, is that right?
Sorry,
You're not involved in investigations?
not other than providing support to events like this.
Yeah. The first of the relevant press conferences took place on the 7th of September 2020. Did you become aware of that press conference on that date?
I arrived to Pristina, I believe, that date, and was informed sometime in the afternoon that the documents were with KLA.
And who gave you that information?
This was again my line manager.
Can I go into private session briefly to ask for the name, Your Honour?
We'll go into private session.
Thank you.
Your Honours, we're in public session.
Thank you. Go ahead, Mr. Rees.
And do you recall what time your line manager informed you about the press conference?
I cannot recall the exact time, but this was sometime in the afternoon as I was flying into Pristina, probably arriving around 3 in the afternoon I arrived, so maybe 4 o'clock or so.
Okay. And it was not until 24 minutes past midday, the following day, that you attended at the KLA WVA office, yes?
That's correct.
So if we say you were informed of the press conference at 4, We've got some ...20 or so hours until you attended at the KLAWVA headquarters.
That is correct.
And in that period, presumably you were of the view that the documents were with the KLA War Veterans headquarters.
According to the information I had, yes.
Yeah. And did you infer from your line manager that he was aware of the press conference sooner than he informed you at 4 o'clock on the 7th of September?
I'm sorry, can you repeat?
From the information you received from your line manager, was it apparent to you that he was already aware of the press conference at some point prior to 4 o'clock in the afternoon when he informed you about it?
Well, as he informed me, I believe he must have known himself.
Yeah. When you attended then the following afternoon, you were with another operational security officer. Yes?
Correct.
And neither yourself nor the second operational security officer spoke Albanian?
Correct.
So you were assisted by an interpreter from ULEX. Is that right?
Correct.
Before you attended at the KLAWVA, had you had any contact with anyone at the office?
The office?
The KLAWVA office?
Yes. Well, not sure where the person is employed. In the evening of 7th, a phone call was made to a number which somebody had found, which should belong to the KLA, War Veterans Association. A phone call was made to see if we could get hold of Mr. Gucati. I believe the person who answered was a IT worker or something.
Right. Mr. Gucati wasn't present when you arrived at the KLAWV office the following day, but you spoke to and dealt with the secretary of the War Veterans Association who was present, yes?
Correct.
And there were a number of others present as well, including a Taibi Miftari, a lady. Do you recall that?
There were several people walking in and out of the office. I can't remember specifically.
Well, Miss Miftari was in fact the first person you met there at the top of the stairs. Do you recall that?
Not in detail, no.
And you asked to see somebody who was in charge that day, and she took you to Mr. Clark, who was the most senior person present in the offices. Do you recall that?
Yes, I believe he was in the canteen.
In the canteen. And he was with a Mr. Pren Marushi?
I can't remember who was with him, but he was with several people at the table.
And having moved to the office, you were joined by a Mr. Chelly Gashi also. Do you remember that?
I cannot remember the names.
But there were others there, yes? And you took coffee with them?
Yes.
Your communication with them, of course, was through the interpreter, yes?
Correct.
So whatever you said the persons that you were addressing were receiving the message through the interpretation of the ULEX interpreter, yes?
Correct. I believe there might have been one person speaking a little bit of English, but anything related to the seizure was done through the interpreter.
Yeah. And it's right, isn't it, that one of the issues that Mr. Klanaku raised was that in relation to the documents that you were discussing with them, they wanted the Kosovan police to have involvement in any handover. Do you recall that?
I can't recall that.
Do you recall in your declaration, you did record paragraph 7, that there was conversation about the KLAWVA discussing handing them over to the prosecution in Kosovo?
Yes, I remember.
So they were raising that they wanted the Kosovan authorities, the police or prosecution, to be present at any handover. Does that help you remember?
I remember that Mr. Klanaku stated they wanted to hand him over to Kosovo prosecution.
So, whereas the atmosphere was quite relaxed, there was a discussion about whether the documents would be handed over to immediately or whether there would need to be a wait, a pause, to allow the Kosovan authorities to be present. Do you recall that?
I can't recall that.
Is your recollection of these events clearer for the 8th of September because you have a note which gives you some assistance, less clear for the 17th and the 22nd of September? Is that accurate?
Correct.
But in relation to the 8th itself, is your recollection of the events that day clear, or is it really confined to what we see in the declaration?
I believe it's fairly clear as I had a larger role in that event.
So when you say you don't recall discussion about a wait to see if the Kosovan authorities could attend, are you saying that wasn't said, or it may have been said but you don't remember that being said?
I don't remember that being said.
So it's the latter of those two alternatives?
Correct.
Thank you. And I'm going to suggest that your response was that to remind them that your authority, the SPO's authority, was superior to that of the Kosovan authorities.
I cannot recall that.
That they would only be involved if the SPO authorized them to be involved. I'm paraphrasing, but that was the general message.
I can't recall that.
Again, would you accept that's something that may have been said, but you can't remember it?
It may have been said. As you stated earlier, this was a calm event. However, there were also a lot of people wanted to speak at the same time. And in the beginning, especially, it was a bit chaotic.
Yeah. And in order to impress upon them that any role for the Kosovan police or prosecuting authorities was subject to the SPO's authority, you said that you could wait for a month in the office, but no Kosovan prosecutor would come, or the local police wouldn't come, unless the SPO approved that.
That was never said.
Of course, what was said to those members of the KLAWVA were present was said to them in Albanian via the interpreter, was it not? So you can't help us with the accuracy or otherwise of the interpretation from the ULEX interpreter, can you?
Correct. but I have no indication of that the interpretation would not have been correct.
Well, but you wouldn't know, would you? You don't speak Albanian, so you wouldn't know, would you?
Like I said, wouldn't know, but I have no indication that it would not.
No. You'd have to be on the other side, wouldn't you, listening in Albanian, to know whether there was an indication as to what was said in Albanian, would you not?
Objection, Your Honor, argumentative, then also non-side.
Sustained.
Your Honour, slightly early, but is that a convenient moment to pause? Is that a convenient moment to break? I know it's slightly early, but it's
If you have a break in what you've got, we will break now for
thank you.
until 11:30. Thank you. We're adjourned.
All rise. All rise.
Be seated. You can bring the witness back in, please, Madam Usher. Please be seated, Mr. Moberg. Mr. Reese will be continuing with your cross-examination. Mr. Reese, you still have the floor.
Your Honour will be pleased to know that on reflection, I think I could be shorter than I had anticipated previously. Mr. Moberg, can you help us with this? Do you know that Mr. Joseph... Sorry.
Pardon me?
I think we realized what was happening and it's okay.
Oh, okay.
I didn't either. I'm grateful for the the interruption from Mr. Pache.
It's good if somebody knows what's going on.
The investigator who you attended with on the 17th of September and the 22nd of September, you know who I'm referring to, yes?
Yes, I do.
That investigator called the WVA offices at 6:50 on the 16th of September, so the day of the second press conference, and discussed with Mr. Klinaku collecting the documents that evening, but Mr. Klinaku said it was too late, and so it was agreed that the KLA WVA would keep the documents overnight, and you attended the following morning. Are you aware of that?
I'm aware that I attended. As for the phone call, I was not involved in that.
Right. Well, are you aware of it? Have you become aware of that?
I can't recall it, but I might very well have been.
Right. So, 2 calls on the day of the first press conference, the day of the second press conference, and effectively on both occasions it was decided to leave the documents in the possession of the KLA War Veterans Association and attend the following day. Is that right?
As I said, I was not involved in the phone call, so I cannot say anything about it.
Well, you accept that that is the chronology, don't you?
Your Honor, the witness doesn't need to accept that. The defense can make that argument later if that's necessary.
I'm sorry. You may answer that question. You can answer whether you accept that chronology, yes or no.
It sounds reasonable, yes.
Thank you. And I'm going to suggest to you that you did on the 8th also discuss and suggest waiting, leaving the documents in the possession of the KLA-WVA for up to a month while consideration was given to the involvement or otherwise of the Kosovan police.
That is not correct.
That is a question I'm putting to you.
Please put it in the form of a question.
I put to Mr. Moberg that that was said. Do you agree with that or not?
I do not agree.
On the 22nd of September, well, firstly, can we have a look at the document SPOE 00220914?
That is P54 for the record.
Thank you. Thank you. So this is P54. Do you recognise that document, Mr. Moberg, or not?
I do not recognize it.
So if I was to ask you who created it, when it was created, you wouldn't be able to answer.
I would not be able to answer.
Okay. You talked about documents being scanned back at the SPO premises in Pristina, yes?
Yes,
When you refer to scanning them, you mean, don't you, scanning documents, turning them into electronic files for the purposes of sending them by email to the offices here in The Hague? Is that right?
correct, encrypted.
They were encrypted, but so when you talk about scanning, just so we understand, not submission to the Xylab system, but they were scanned, they were sent by email, I think, in relation to the documents from the 22nd of September, I think in 11 separate emails to, I won't name him, but the assistant to the Deputy Specialist Prosecutor. Are you aware of that or not?
As I said, I will not be involved in that process, so I cannot say
Okay, so
anything.
you can't assist us with the detail of who was involved, the format, when documents were sent, and so on.
Correct.
Okay, let me then, I think, just deal with one further topic. And again, if you can assist, please do. If you can't, please say so. But what knowledge, if any, do you have of the investigation that's been carried out by the SPO into the process by which documents came to be delivered to the KLA-WVA?
I have no involvement.
So does no involvement mean no knowledge?
Correct.
No, thank you, Mr. Moberg. No further questions. Well, with one reservation, that if there is further disclosure that has an impact, then we may, in those circumstances, ask for this officer to be recalled as with the others.
Understood the reservation. We've been, I think, fairly explicit that you will be allowed to withdraw witnesses upon a proper application if necessary. Mr. Cadman, you have the floor if you'd like to cross-examine.
Thank you, Your Honour. As yesterday, I will be adopting the position taken by my learned friend, and I just have a couple of additional questions to ask.
Go ahead.
Mr. Moberg, you've stated that you were not involved with the telephone calls that Mr. Rees just took you through. The reason for that is, as I understand it, and as you've confirmed, you don't speak Albanian.
That is correct.
Can you also confirm that the officer, the investigator that Mr. Rees has referred to, that attended with you on the second two dates, and I appreciate your memory is hazy as to those dates, but that officer, investigator, does speak Albanian?
That is correct.
And that during that time, as you've said, you were not able to follow the conversation on the basis that the conversations were taking place in Albanian, and your only interaction with Mr. Haradinaj was actually in Swedish?
Correct.
You mentioned that there was a brief conversation, although it, as I think you said, it was just introductory conversation with somebody who spoke English. Do you recall who that person was?
I can't recall the name.
If I can just take you to your declaration of 21st of October 2020. I apologise for the P number, but 083988 that we've already heard this morning.
That's P92, Mr. Cadman.
I'm grateful, Your Honour. We can just turn to the last page at paragraph 13. At paragraph 13, there's a reference that you had requested a cover page that Mr. Klenaku was unaware of. Actually said that there was no cover page in existence. Is that correct? Is that your recollection?
Correct.
And certainly no page was ever identified or discovered.
Not to my knowledge.
And actually, the discussion was that any reference to any further material was made when the mysterious man dropped that material off. That was certainly Mr. Klenaku's position.
I'm sorry, can you ask the question?
Is that a question, Mr. Cadman?
The response from Mr. Klenaku was that any reference to additional material was made by the person who the mysterious man, who had dropped off the material, and there was certainly no note that he was aware of. Is that your recollection?
Yes, that's my recollection of what Mr. Klenaku told me.
Subject to what Mr. Rees has already said, we reserve the right if the need arises, but I don't have any further questions at this time, Your Honour.
Thank you. Any redirect?
Your Honor, no redirect. I just wanted to ask the court whether the witness needs to be present for me to read the summary of P92, which has now been admitted, if the court wants that to happen.
You want to make a summary of P92?
Only because it was admitted pursuant to Rule 154, Your
okay.
Honor.
All right. No, we are going to have some questions of him, so we will wait until after our questions, then the witness will be excused, and then you can do your summary. So, Judge Gaynor, I think you had a question or two.
Thank you very much, Mr. President. Mr. Moberg, just a couple of questions about your duties within the SPO. First of all, when did you start working for the SPO?
I've been with the SPO since the beginning of the organization. I was previously to that also employed with SITF for some months.
Right. Could you put a month or a year on it?
I joined SITF in 2015, and then in 2016 was transferred over to SPO.
Right. In your evidence, you've told us you're an operational, excuse me, an operational security officer. Now, today at page 30, line 22 of the transcript, I'm saying that for the benefit of the other participants, Mr. Moberg, you were asked, you are not involved in investigations, and your answer was, not other than providing support to events like this. Do you recall that evidence?
Yes.
Right. Could you help us understand your role as an operational security officer in general terms, in a few sentences?
In general terms, as an operational security officer, a lot of the work is performed in the field, providing security for staff members, also working closely with other departments in terms of witness security, security of interlocutors. Most of the work is being done in the field.
Okay. And during your period of service with the SITF and SPO, what kinds of staff do you interact with as part of your professional duties within the SPO?
That would normally be investigators, prosecutors, witness security.
Now, over the course of your duties with the SITF and SPO, have you ever had any reason to believe that any current or former member of the SPO was involved in any way in the delivery of any unauthorized information to the KLA War Veterans Association?
No, Your Honor.
Have you ever had any reason to believe that any person acting under the instructions or control of the SPO was involved in any way in the delivery of unauthorized information to the KLA War Veterans Association?
No.
I have no further questions. Thank you, Mr. Moberg. Thank you, Mr. President.
Thank you, Judge Smith. Good morning, Mr. Moberg. I just have a simple question that pertains to the 8th of September. Did you yourself transport the material that was seized from the KLA War Veteran Association to your offices in Pristina? Were you physically present during the transport?
Yes.
And did you remain present with the material up to the point when it was scanned and digitalized?
Yes, I believe that's how the material was handed over to someone I can't recall.
Thank you.
Thank you, Mr. President. Good morning, Mr. Moberg. I also have a couple of questions for you. My first question is, you said earlier this morning that Mr. Haradinaj already knew that you were Swedish. Is that correct?
That was as we met twice on the second and third occasion. So that's when he learned that I was Swedish.
So
On the first of those occasions.
All right. And my second question is, you also stated in one of your notes, or better, declaration, the declaration dated the 3rd of November 2021, that you were told by the interpreter that the call Mr. Klinako made before he handed over the documents to you was to Mr. Gucati. Could you please specify this? In particular, could you, or maybe can you recall what the interpreter told you about how he figured out that he was, or Mr. Klinako was talking to Mr. Gucati?
Yes, we were sitting in Mr. Gucati's office. Mr. Klinako was sitting at the desk and made the phone call in front of us.
So you heard?
I heard the phone call, but of course I could not understand what was being said, but I believe afterwards, when we've left the office, the interpreter informed me of this.
So did you hear Mr. Klinako mentioning the name Gucati, or
No.
was it just told?
I can't recall.
But it was told, you were told by the interpreter that he was, Mr. Klinako was talking to Mr. Gucati.
That is correct.
And what, can you recall what he said to you?
The
The
interpreter?
interpreter, yeah.
Nothing more than that the phone call was made to Mr. Gucati, and it sounded like he was informed that documents should be handed over to us.
Okay. And my last question is, in your note dated 21st of October 2020, this is P92, you wrote in paragraph 7, just a second, that FK, I assume that this is, you're referring to Mr. Klinako, right, with FK?
Correct, Your Honor.
Also informed DM, this is yourself, is that correct?
Correct.
That 3 copies of these documents had been provided to the media, specifically to Kosovo Press, Gazeta and Focus and T7. My question is, did Mr. Klinako tell you why these copies had been given to the media? Did he mention any reasons for this?
I cannot recall mentioning any reasons.
Okay. Thank you very much, Mr. Moberg. No further questions.
All right, unless there's some extraordinary reason, we will be finished with Mr. Moberg. Nothing from anyone? Mr. Moberg, thank you for being with us. You are excused. Your time here is completed. Thank you for being with us.
Thank you, Your Honor.
I'm sorry. All right, Mr. Potts, for your submission.
Yes, Your Honor. So the first thing I will do, as I mentioned, is I will read the summary of P92. I also have 3 other brief matters to raise. The summary that I'm going to read in relation to Exhibit P92 admitted earlier today is contained in filing F00411, Annex 1. In P92, W04876 states that, together with other SPO staff members, an interpreter, and an independent observer, on 8 September 2020, he attended the KLA WVA premises in Pristina. There, he read excerpts from the single judge's 7 September 2020 decision authorizing a seizure and Rule 42 of the Rules of Procedure and Evidence to KLA WVA representatives. W04876 states that he handed over a copy of the decision to Fatan Klinaku, who handed over documents to W04876, and that both signed the handover document. W04876 states that Klinaku noted that the documents he handed over were those which unknown persons had provided to the KLA WVA the previous day, and that copies thereof had been provided to 3 media outlets. W04876 states that he recorded CCTV footage played on a screen at the KLA WVA office. W04876 states that he subsequently placed the documents seized from the KLA WVA office in evidence bags along with the handover form and sealed the evidence bags. W04876 states that at a later date he handed over the sealed evidence bags to a colleague for their transportation to the SBO office in The Hague. And that concludes my reading of the summary, Your Honor. If I can move on to the other brief matters.
Go ahead, Mr. Potch.
Thank you, Your Honor. First of all, I can't recall whether I noted, but Mr. Halling is not present during this current session.
Say that again, please.
Mr. Halling is not present during this session. I can't remember whether I noted that or not earlier today. And the next thing that I would like to address, Your Honor, as foreshadowed in relation to the order for disclosure today, and that's the one contained in F413, I would now like to make a request for suspension of the order contained in paragraph 95B of the decision F413. And this is due to the fact that the SBO intends to file today a request for leave to appeal pursuant to Rule 77 in relation to that specific order. The implementation of this order, which is due today, would entirely defeat the purpose of the relief which will be sought in our leave to appeal, and thus lead to irreversible consequences. And for those reasons, Your Honor, we request that you suspend that order. Again, I'm only referring to paragraph 95B. And to clarify, Your Honors, the SPO currently still intends to undertake the order in paragraph 95C, and will then address that as necessary at a later stage. That's all I have for Your Honors, unless you have any questions. Actually, I can also add that if the leave to appeal is filed after 4 o'clock, we would be very happy to provide a courtesy copy to the panel and the defense so that it doesn't arrive on Monday in case that assists in any way with speeding up the process.
Thank you.
The next matter I'd like to address, Your Honor, is we inquired with witnesses 4841 and 4842, and they could be available. Of course, if we get a few days' notice, that would be best in terms of mission planning and other issues. And I believe the last thing I wanted to address today is in relation to this morning's order on admission relevant to witness 4841, specifically in relation to item P104 MFI, which we have referred to as batch 2. The SPO does intend to take the panel up on its offer and provide a redacted version of those pages by close of business today. And the SPO would also like to, in the spirit of that order, apply similar redactions to the corresponding pages from that batch in the other batches, because once we are providing a redacted version of those pages, in our opinion it makes sense, as we have asserted that these pages also appear elsewhere, to provide those, given that it would be the same content. But of course we're guided by Your Honor, because of course I note that this goes slightly beyond the scope of what you instructed this morning. So we will appreciate your guidance on that issue.
Anything else, Mr. Potch?
No, thank you, Your Honor.
Thank you. Mr. Rees?
In relation to the request for suspension of the disclosure order, as I understand the rules, any appeal against that order will be an appeal requiring certification under Rule 77. Rule 171 provides that there shall be no suspensive effect unless otherwise ordered in the certification decision. So, to the extent that this is an application for suspensive effect prior to the filing of an appeal, of a request for certification, and indeed the provision for allowing any response to that request, and indeed the decision itself, it is a application that has no basis in the rules. Rule 171 is perfectly clear. Subject only to Rule 58.4, which deals with interlocutory appeals against detention, so we can set that aside. Interlocutory appeals shall not have suspensive effect unless otherwise ordered in the certification decision or by the Court of Appeals panel. This request is not based in the rules and is premature.
Thank you, Mr. Rees. Mr. Potch, so as I understand, you've asked for a suspension, but you have not filed a motion for an interlocutory appeal.
Correct, Your Honor, and to be completely clear, I'm requesting a suspension now, more of a courtesy and in the interest of the efficiency of proceedings. That request could also be contained in the filing which we'll file today, but mindful of the fact that the deadline which is at play at the moment is today, I thought it best for the office to provide notice of our intentions so that it doesn't appear as though we are not mindful of your day.
I understand that.
And thank you, Your Honor. And just on one other point, we do note that Rule 77 actually allows for up to 7 days for a party to file a request for leave to appeal. We, of course, understand that an appeal on this issue would require certification. So, again, mindful of the order for disclosure today and the fact that this is a matter which everyone would be happy for it to be resolved sooner rather than later, we do intend to file that request today, which is entirely within our rights. That's our position. Thank you, Your Honor.
I think it's safe to say we'll deal with it when we see the documents filed. So, and I also take it you are not resting your case today because of these issues.
Your Honor, at the moment, we don't intend to call further witnesses. The one issue that was quite central to the SPO's case was the one which resolved the admission of items in relation to 4841. Of course, I cannot say that we rest our case today, in particular because of the disclosure of P104, which we will then renew our request. And we may also be requesting, in addition to admission of that item, admission of the corresponding unredacted pages from other batches. So at the moment, that is all we envision. Of course, the SPO will address any further issue which may arise as a result of any decision as to disclosure of other items, including 1023.
And will all of this material be available to us by Monday?
Your Honor, just to clarify, the P104, which is the batch 2, will be provided today. Mm-hmm. The other material which is at issue is, of course, that which is subject to disclosure pursuant to the 1023 decision.
Right. Yeah, that's not what I'm talking about. I'm talking about the appeal, the request for certification, the suspension. All of that will be filed and available to us by Monday.
All of that will be available today, Your Honor.
All right. Mr. Rees.
Can I say that I would endorse the position expressed by Mr. Pache that the SPO's case should not formally be closed until all disclosure matters have been resolved. Secondly, the point that I wish to make about Rule 171 and the suspensive effect matter is not just that the application is premature, in that the application should be made together with the request for certification, but Rule 171 does not provide for a suspensive effect pending a decision on an application for certification for appeal. Rule 171 expressly says that in the period of both seeking leave, the appeal shall not have suspensive effect unless it's ordered in the decision on certification. It's not pending certification. That was the point that I wish to raise.
It does seem, Mr. Patch, that you kind of waited to the last minute to do this, which puts you in a bad spot.
Your Honor, in terms of being at the last minute, I note that the decision which we're seeking leave to appeal is dated the 3rd of November and was filed at 5/18, so it's not that much later.
No, I know, but you still have a short period of time in which to act.
I'm not sure I understand the
Go
reference,
ahead.
Your Honor.
Go ahead. You stood to say something.
Yes, Your Honor, just that the reading of the defense in relation to Rule 171 is illogical. Of course, if you're requesting suspensive effect, that would be entirely useless if the matter at issue, in this case the disclosure of the information at issue, would have happened already. That cannot be and is not the correct reading of Rule 71, so it is entirely within our rights to make that request and for the panel to rule on that. And again, I reiterate that the deadline set by the panel was for today. The usual deadline for seeking leave to appeal is 7 days, but we are really acting in the interest of efficiency of proceedings and seeking to expedite the manner as best we can.
It will be the order, oral order, that the disclosure deadline is extended for you until Monday so that you have an opportunity to deal with this. Your point's well taken, Mr. Reese, I understand it. And that will give us an opportunity to deal with this entire matter at one time. I do have a couple of other matters. I take it you're finished then, Mr. Patch?
Just to clarify, Your Honor, because you mentioned that the disclosure deadline is extended until Monday.
Yes.
Of course, we'd have no issue with that if our leave to appeal request to be filed still is determined by Monday. That's the
It
understanding.
probably won't be. It'll probably be, well, it may be determined first thing Monday, but we have to spend some time looking at all this.
Of course, Your Honor, in which case, of course, the request for suspensive effect makes sense in our submission until the determination thereof. So I don't know that we can say Monday because that depends on a decision being rendered.
We'll deal with Monday on Monday then.
Thank you, Your Honor.
Mr. Cadman, I had a couple of things for you. You asked for an extension to file your new expert report until Monday. I noticed that the deadline for the panel set in an oral order on October 26th seems to give you until the 9th of November, which is Tuesday. Is that going to be sufficient?
Absolutely.
Okay.
I've spoken to the expert in the break, and he said that subject to transcripts, which I think we're still battling with, I had anticipated that the deadline was today, which is why I raised it today. So that's my mistake.
Understood. We just wanted to recheck that. Okay, the deadline stays for November 9th. The SPO can file its notice pursuant to 149.2 within 7 days of notification of the report if you wish to respond. to the SP notice. Mr. Cadman, you will have 5 days from the receipt of the SPO notice, and that ends this oral order. While you're still on your feet, Mr. Cadman, almost, can you now confirm whether your client wishes to make a statement on Monday?
I can confirm that.
All right. Or do you, whether it's closed or not, do you both want to make your statements on Monday? It's perfectly all right. We're not arguing about it.
Certainly on my part, that makes some sense.
Okay. Okay, both, you too, Mr. Hedman? All right. We'll provide some time for that then. Mr. Reese, further to your request to defer any cross-examination of witnesses 4841 and 4842, the panel rules as follows. The SBO is required to come back with a report on the outstanding Rule 1023 matter by November 12th, and that may end up being changed because of these matters that we've just discussed. As we heard this morning, we might also have a request for certification, which we now know we will have. So this may lead to further steps. Once all of the matters are ruled upon, you will have 5 days to decide whether you want
Can you slow down, please, Your Honor?
to request further cross-examination, and then the panel will hear your request at that time. That's all. Anything further? Looks like we'll see you all here at 9:30 on Monday, and we'll hopefully be in a position to deal with everything that has now been announced. So we are adjourned until 9:30 on Monday.
All rise.
Thank you.